Can you please help me get to the page? Today, we are discussing a very important topic. We are discussing a very, very important topic. And that is, can you please, okay, physical presence requirement. No, that's not the topic. Exception to the physical presence.
Oh, okay. Sorry, exceptions?
Exceptions to the physical presence requirement. That's the topic, yeah.
Okay.
Please change it. The topic we are discussing today is based on popular demand. In fact, in the past, I thought I have dealt extensively with citizenship requirements. But this particular question, what are the exceptions to physical presence requirement for citizenship purpose, is based on series of questions that I receive on personal notes, and people keep asking the same questions over and over and over again. And I realize how important this topic is, and I have decided not only to handle it as a separate topic today, but I will handle it in a way that I've actually not handled any of our podcasts since we have been doing this for years now. I'm going to follow the statute, read the requirement of the statute, and then explain it. In fact, I printed it out so that from my computer so that I'll be able to explain it extensively. So that after today, anybody that have any question relating to eligibility for citizenship, anyone who is a permanent resident, or even a foreigner thinking about how to become a U.S. citizen without physically living in the United States, I believe this topic will be very, very beneficial. Again, welcome to our live podcast. This is Dr. Olu Asekun here. We do this every Wednesday, 12 p.m. Central Standard Time. If I recollect correctly, that should be 7 p.m. Nigerian time currently, because here our time changes. So what are the exceptions what are the physical presence exceptions to citizenship in the United States? As I stated, I've divided it into, I think, 4 categories. Yes. I've divided it into 4 different categories for ease of explanation. There are 4 categories of exception to physical presence requirement for anybody who is a permanent resident and desire to be a U.S. citizen. So the first one, I'm going to talk about military-related exceptions. When I say military, apparently I'm referring to U.S. military. Military-related exceptions. That is the key. So, the first one, if you are a permanent resident and you are serving in the U.S. military and you are posted abroad, of course, that is almost impossible, because if you join the military and they decide to post you abroad, they will give you citizenship right away before posting you abroad. But for spouses, yes, spouses of U.S. citizens who are posted abroad, as soon as you get your green card and become a permanent resident, you don't necessarily have to meet the physical presence requirement, because the law requires you to be a permanent resident for 1 day. 1 day. And it doesn't matter whether you are physically present in the U.S. or you are with your husband or your wife where he or she is posted abroad in military capacity, you are eligible for citizenship. The physical presence requirement will not be applicable to you. Now, this includes spouses of U.S. citizens. It also includes children of U.S. citizens who are under 21. Of course, if you are over 21, you are already considered an extended family member, so you may not benefit from those things. But children and spouses of U.S. citizens, they will be exempt from the physical presence requirement. That is the first category. Now, let me say this before I go into the B part. For the children, it does not matter whether they are living with their US citizen parent that was posted abroad. It will not matter. Wherever they live, they will still be eligible for citizenship. So I wanted to clarify that. So let's go to the next one. So the next exception, the way I categorize it, like I said, I'm doing this podcast today in a way that I've never done it before. So before I go into the next one, I want to show you what the statute says about this so that whoever listens to this podcast after today, you will not have any questions as to how to be eligible for citizenship without living physically in the United States. That is why we decided to treat it as a separate topic today. Now, the law that deals with the military is under INA, Immigration and Nationality Act, chapters 328 and 329. Now, the law requires that the person in active military must have served in the military for at least 1 year. At least 1 year. So that is the first category. The second category, at least one of these must be applicable. Anyone who served in the military during period of hostilities. Period of hostilities simply means during war. You know that people can be posted abroad even during the time of peace. Right now, for example, I know that U.S. military, they have military members stationed in the UK. Meanwhile, they are not in any hostility with the UK. They have military members stationed in Germany. They are not in any hostility with Germany. So the fact that you are posted abroad, yes, that qualifies you under this category, qualifies your immediate family member, that is your spouse and your children. But I'm also saying, in addition to that, if you have been in the military before, during a period of hostility, during a period that the US was engaged in war or in a form of hostility, for example, those who were posted to Afghanistan or to Iraq during the Iraqi war, it doesn't matter whether you are still there now, but because you fought during a war or during the period of hostility, your family members can still be eligible for citizenship even without physically present in the United States. So that is what this one is saying when I refer to period of hostilities. Of course, it also covers people who served during the World War II. Of course, I'm sure World War II ended in 1945. So whoever served in World War II by now, if they are still alive, I don't think they will be talking about U.S. citizen. But in case, the law is still there to cover them. Then it also covers people who enlisted in the military under what is known as Lodge Act. Again, these are old statutes. These are Lodge Act. That was the period of June 30, 1950. I was not even born then, and I'm not young. At least I'm I'll be 60 in a couple of months. So if somebody who was born in 1950, but again, the law is still there. I'm just stating what the law says. But generally, that is what is covered under the exception to physical presence requirement under Part A of my analysis today. So now I'm going to go into Part B. What is the next exception for citizenship purpose? Now, Part B, I'll be talking about exceptions based on US government or specified entities. Exception based on employment with US government or specified entities. What do I mean by that? Again, let me start from the statute. While I'm doing this, if you have questions relating to except physical presence requirement, exception to physical presence requirement, if you have questions on it, please send it. For today's podcast, please take note. I'm not going to answer any question outside of this topic today because this is a topic that I'm addressing based on popular demand. I thought we have dealt extensively with citizenship before, and I'm sure we have a podcast on general citizenship question. But for today, we are restricting it to exceptions or a physical. Can you please post the topic again? Let it be there on the screen permanently. So, because I'll be referring to it myself from time to time. Yeah, I think it's exception to physical presence requirement. Did you post it? I can't see it.
It's just too long. Yeah, it's so long.
Okay, yeah, exceptions to physical presence requirement for citizenship purpose. So that is the topic we are discussing today. So if you have questions on that, in other words, if you're already a permanent resident, but you are not sure whether you'll be able to stay here in the US to meet the physical presence requirement, because for anyone to become a US citizen, if you have a green card, depending on your category, some people are required to be a permanent resident for 5 years before they can be eligible for citizenship. Some people who are married to US citizens, they are required to be a permanent resident for 3 years in order to be eligible for citizenship. People who are married to a US citizen and they were abused, they are victims of violence, and they subsequently obtain their green card through VAWA. They are eligible to apply for citizenship after 3 years of becoming a permanent resident. However, apart from these 3 years, 5 years requirement for physical presence, what are those exceptions? What if you have your green card but you are not able to stay here physically for 3 years or for 5 years in order to be eligible? What are those exceptions? So those exceptions are the one we are discussing today. So, and I said I'm going to do today's podcast in a way that I've not been doing it before. So I'm going to categorize it into 4. So the first one is the one I just finished. That is, if you are in the military, your family, if you are in the military, you are in active military duty, your families are exempt from physical presence requirement. And I explained that the spouse and the children. I went further to say that even if you are no longer in the military, but if you are in the military during the time of hostilities, hostilities means during the time of war. If you actually went to war on behalf of the US government, it doesn't matter whether you are still in the military or not. At any time you decide to apply for citizenship, your spouse and your children will still be able to become a US citizen without having to meet the physical presence requirement. So That is the first exception. So the second exception, not the second, the B exception, because I categorize it into part A, B, C, and D. So the first one is the military exception. The second one now that I'm going into, that is the U.S. Employees of U.S. government or specified entities. Employees. Let me say this. The B part will be the employees of US government. The C part will be certain media organizations, and the D part will be religious duties. So I'm on B right now, the B part, which is employees of US government on or specified entities. Like I said, because of the way I've decided to handle today's podcast, I'm going to state what the law says about this before I explain it. Now, for employees of US government or specified entities, the exception of physical presence are waived on conditions. Remember when I was discussing part one, there were no conditions. But in this particular one, there are conditions that must be met. The first condition that must be met is that this person must have actually been physically present in the US for at least 1 year. For at least 1 year. So if the category is that you are required to be a permanent resident for, can I get a pen? Something came to my mind. I want to quickly write it down before I forget. Okay, thank you. Okay, thank you. Now, the first exception, you must have been physically present in the US. Now, maybe after that, you are posted abroad. Of course, US government is not going to employ somebody who never lived in the US. So if you have never lived in the US, this exception may not be applicable to you, because the first condition is that you must have lived in the US for at least 1 year. Now, maybe after that, you are posted abroad by your employer, who is either a US government or certain entities that I'm going to explain now. If you fall into that category, the second condition is that you must apply. There is a form called form, is it I-470 or N-470? I think it's N-470. Can you quickly help me check? I think it's N-470, but just to be double sure. You have to apply for that form. This is like a permanent resident who is going abroad for an extended period. You will need to file Form I-131 in order to get the USCIS passport, and then you can stay abroad for years without affecting your green card. So in this category too, if you are working for a US government abroad, or you are working for certain American companies abroad, you still have to fill this form N-470 and apply and be approved.
Yes, it is N4.
Is N-47? Okay, yeah. Since we are talking about naturalization, I believe it should be N, but I just wanted to be sure. Yeah, from N-470, you have to fill it, pay for it, apply for it before you go abroad. So even if you work for a US government or companies that fall into this classification, if you don't apply for this N-470, you may still not be able to waive this physical presence requirement. So that is very, very important to note. So now, talking about, I want to explain specified entities, because US government It's very clear. If you are working for the US government, that is very clear. Maybe you are working for generally people who work for the Department of State, majority of them work abroad. People who work for the military, Department of Defense, some of them work abroad. People who work for maybe foreign affairs, I don't even know, do they have foreign affairs department in the US? I think the Nigerian in me is talking about Ministry of Foreign Affairs. But do you have Department of Foreign Affairs? I don't think so. What does Department of State do? That's what Department of the State do. I don't think they do. I think it is Department of State, not the Foreign Affairs. But anyway, if you work for the US government, that is very clear. But I want to discuss the other companies that are non-US government. And I want people to pay attention to this because this is where a lot of people miss it. And this is very tricky. And that is why I've taken the pain to write it down so that in the course of explaining it, I will not make a mistake. Yes?
It is the Department of State.
Yeah, I thought as much. The internal affairs thing, that's the Nigerian part of me that was saying that. I know they don't have any such department. Whatever the Ministry of External Affairs does, I know in the US is covered by the Department of State. Yeah, so it's those who work for the Department of State that take care of foreign affairs.
Formerly known as the Department.
Yeah, they are the one that works in foreign. It is the Nigeria in me because in Nigeria we have Ministry of Foreign Affairs. So that's why I was thinking about Ministry of Foreign Affairs.
Well, it used
So
to be.
my audience will be,
In the U.S., it used to be called the Department of Foreign Affairs, but the name change the name was changed by Congress in 1789.
you see, they have been Department of State since 1789. So that's a no. Well, good to know. I mean, no knowledge is lost. So that information can be useful one day. So they've been Department of State since 1789. So that was that's almost 300 years ago or even more. Well, anyway, so talking about the specified government, I want to explain it very carefully. Now, a US firm that is working for a foreign international organization that the US is a member or either by a member by treaty. A foreign international organization that the US is a member by treaty. Example, the United Nations. US is a member of the United Nations. The G7, I don't know if they have organization, people working for them, maybe the G7. Another one is World Health Organization. That is another international organization. These are examples of organizations to which US is a member by treaty, or maybe what is this military arm that is stationed that Russia is always talking about? Is it NATO? NATO. Maybe NATO is another one because you have US military working for NATO abroad, even soldiers and civilians working for NATO abroad. Yeah, NATO will be another one. So an international organization to which the US is a member by treaty. So that is the first category of that specified entity. Now, some private companies may be involved. Some private companies may be involved, but this is the criteria for any private company to be eligible. So for the private company, the US firm who owns a US based firm or company that owns a foreign subsidiary. I don't know. Let me explain it differently. Let's say this law office of Olu Asekun PC, is a registered business in the United States. If the law office of Olu Asekun PC decides to open a subsidiary in a foreign company outside the US, if that company hires somebody who is a permanent resident of the United States to work in that subsidiary office outside the US, they will be able to waive this physical presence requirement if one, the nature of the business that we do is such that it will encourage commerce in the United States. Two, if the shares of the company is owned by the US company at least 51%. So if I partner with another person abroad and then our shares is 50-50, I own 50%, that person owns 50%, that will be a disqualification. This person will not qualify. The physical presence requirement will not be waived. For the physical presence to be waived, the US company must have at least 51% of that subsidiary. Two, the nature of the business must be such that we encourage commerce here in the United States, not abroad, in the United States. Three, the applicant must also apply for that form N470 and get approved before believing that the physical presence is going to be waived. So those are the conditions. Of course, once the physical presence is waived, once you file the N470 and you get approval, then you already know that your stay abroad is not going to affect your citizenship eligibility. So if you stay abroad for 5 years, it will not matter. You will still be eligible to apply for citizenship because the physical presence requirement must be waived. But it is very, very important to understand those three requirements. It is mandatory. So it doesn't matter that you you work for a US company abroad. No. If you work for a US company abroad and you do not meet those requirements, you will not be able to waive the physical presence. But if you work for a US company abroad, number one, the company must be either wholly owned by the US organization or it may be a subsidiary. Where it is a subsidiary, the US company must own at least 51% of the shares of that company. And of course, the purpose of the company must be to encourage commerce here in the US, and then the applicant will need to apply for Form N470 and get approved before you now decide to live abroad. But if all these conditions are met and you decide to live abroad, you will still be able to obtain your citizenship without any problem. Now, I'm going to go into the third part, part 3, because I see that time is far going. So part 3 is talking about certain media organizations. Certain media organization. We already know what media is. There are lots and lots of media organizations. It could be audio or video or written. There are different media organizations. It could be television like CNN, ABC, is it CBC or CNBC?
CNBC.
There is CNBC, there is CBC or something. Three words like that, yeah. They are local channel 5. Local channel 5.
Isn't that ABC?
No, ABC is local channel 8.
NBC.
What about 11? There is NBC, there is ABC, there is CNN,
Okay.
there is CBC.
ABC, CBS.
CBS is what I wanted to remember. So ABC, CBS, CNN, Fox News,
Fox.
CNBC.
PBS.
I mean, any television organization, U.S. television organization or media organization. It could also be print media like Dallas Morning News, New York Times, Washington Post. I mean, U.S. media organizations. Now, interesting thing is that even for US media organizations, guess what? They don't even have any conditions. You don't need to fill from N470 or do anything. All you need to show is that you are working for US media organization. That's it. So you may just need to provide your letter of employment and then your letter of deployment abroad. And that is understandable because if you are working for media organization, if there is urgent news, they don't have to that they need you to cover. Maybe okay, right now there is war in Ukraine and this thing. So if they decide to post you there, they don't need to first apply to USCIS and wait for an application that may take months. Maybe by that time a lot of things will have happened. How are you going to cover the news? So it is waived for them entirely, no conditions attached. So if you are a permanent resident and you are working for a US media organization, the physical presence requirement is waived. Physical presence requirement is waived for employees of US media organizations working abroad. That is very clear. I don't even think I need any much explanation on that. Okay, now, before I go into the next one, I think I'm going to, the next one should be C now. Yeah, no, D. The next one should be part D. That is religious duties. Part D. But before I go into part D, I'm looking at my notes here and I see certain things that I feel is very important that I mentioned regarding the certain media organizations. Now, the fact that there are no conditions, you don't need to apply for N470. Those are very clear. But there are certain things that you need to note. Whenever you come back to the United States, you must indicate interest. You must indicate your intention to take up residence in the United States whenever you resume whenever you finish your service abroad. So in other words, let's say you work for CNN and CNN posted you abroad. You were there for 3-4 years. And then they told you that the foreign work is over. You need to come back to the US. And then maybe you decide, you know what, I like it here. I'm going to stay here. No, that would be a no-no. So at the time you are going to apply for naturalization, if you are still abroad, you will have to show intention to come back and live in the US upon your service abroad. That maybe, I don't know if I should call that a condition, but it's not a condition because it's after. But we can still call it a condition. So I just want you to know that, just so that you don't say, oh, Lawyer Asekun said there is no condition. Well, I don't know if you call that condition or not, but upon your service abroad, you must declare your good faith intention to take up residence within the United States immediately upon termination of your employment abroad. So if you tell them, you know what, CNN is posting me to Belgium, therefore, I'm not able to live in the US for the purpose of naturalization, so I want you to waive the physical presence requirement for me. USCIS is saying that, okay, we will waive it. However, you must give us good faith declaration of your intention to take up residence within the United States immediately upon termination of your employment abroad. So that is very key. Very, very key. Now, I want to go to the part D, religious organization. I want to do that so that at least I can have time to review some of the questions. I already perceive that I will probably be going over 1 p.m. today. That is understandable because we also did not start on time. So, part 4, religious duties. Since I said I was going to be referring to the statute, so that is why I want to make sure that I have my note handy so that I don't miss out important thing. Because I don't want people to just believe that, oh, you know what if I just start a church here in the US and then go abroad? I want you to understand the requirement. If you want the physical presence to be waived for you as someone who has a religious duties abroad. Yes, for religious organizations that are ministering or doing missionary work abroad, physical presence requirement may be waived. But of course, there are conditions which I'm going to go over. So for anyone who is a permanent resident but who is ministering or doing missionary work abroad, physical presence may be waived if the following conditions are met. Physical presence may be waived if the following conditions are met. Now, the first condition, the person must be performing the ministerial or priestly function of a religious denomination with a bona fide organization within the United States. In other words, it cannot be a foreign religious organization. It has to be a United States, probably tax-exempt religious organization. So just like this is equivalent to the requirement of religious work petition. So the petitioner or the organization must be a US-based organization, even though the law does not specifically state that they must be tax exempt. But I know that the tax exempt requirement, that is one of the ways that religious organizations that is registered in the US, by being tax exempt, that is one of the means of identification for this type of religious organizations. That is one of the means of identification for this type of religious organization. Now, the second condition, the person must be serving as a missionary or a brother or a nun or sister and must have been engaged solely by a religious denomination or interdenominational mission having a bona fide organization in the United States. So, you can be a missionary, you can be a brother, you can be a nun, you can be a sister, but you must be working for a religious organization that is registered in the United States and working in the United States. So you need to have those things. Then the third requirement, applicant must have been physically present and residing within the United States for an uninterrupted period of at least 1 year before the naturalization. So what that means is that you cannot become a permanent resident today, 6 months after you decide to go abroad and claim that you are working for a US religious organization. No, the statute is saying that after becoming a permanent resident, you must have lived in the US for at least 1 year, 1 full year, before you can decide to go and start working for the religious organizations abroad. I believe this is probably one of the check to ensure that this is actually a good faith effort of a religious organization. If a U.S. religious organization employ you and you have not even worked for them for 1 year, why would they be sending you abroad in the first place? I mean, you are a foreigner. You are not a U.S. citizen. You are a foreigner. You came here. You became a permanent resident. You have not even lived here for 1 year, and then the organization is saying they want to send you abroad. USCIS is saying no. You must have worked for the religious organization. You must have been in the US for at least 1 year, not necessarily getting paid with the religious organization, but at least you must have lived in the United States. That is the requirement of the law. I don't want to misinterpret it. The requirement didn't say you must have worked for the company. The requirement says that you must have been physically present and residing in the United States for an uninterrupted period of at least 1 year. Uninterrupted means that it has to be 1 year straight. You cannot travel abroad within that 1 year. So even if you have lived in the US for 1 year, but within the 1 year, if you travel to Canada for 2 weeks, or you travel to UK for 2 weeks, that is interruption. That is why I'm not, for this purpose, I'm not saying these things from my head. Not that I didn't know it, but I decided to write it down so that I don't miss the important factors. So one of the important factors in this case is that you must have been physically present and residing with the United States for an uninterrupted, that is the key, uninterrupted period of 1 year. So any short trip out of the US will interrupt it. So which means you will come back and stay another year. But you must have lived in the US for an uninterrupted period of 1 year, after which you can now go and work for the religious organizations abroad. So that is very, very key. Now, while the applicant must establish 1 year of uninterrupted physical presence, he or she may comply with this requirement at any time before filing the naturalization application after becoming a permanent resident. So what this is saying is that it doesn't mean that 1 year must be immediately before you apply. The 1 year may be 2 years ago that you are here in the US. It may be 4 years ago that you are physically in the US. But after you became a permanent resident, after you got your green card, you must have lived in the US for an uninterrupted period of 1 year. Then anytime after that, you can now work for a religious organization abroad. And then they will still waive the physical presence requirement for you. So it is very, very important. And also, the next requirement is that this one too, applicant in this category must file the Form N-470. So far, all the 4 categories that I've listed, the only one that is exempt from the 470 is people working for the media, US media organizations abroad. Those are the only one exempt from the 470. But for those who are working for religious organizations abroad, they will need to file Form N-470 in order to meet this requirement. The difference, however, is that they don't have to wait for the 470 to be approved. Unlike other categories, they can file the 470 before, during, or even after they already travel abroad. They can file it at any time. They will just need to show documentary evidence of their eligibility. So that is very, very, very key. Now, Part D and the last one, those are people who are working in security related. Let me look for the people who are working security-related duties on behalf of U.S. military abroad, maybe interpreters, let me look for their own notes. Okay, translators and interpreters or security related positions. If you are working abroad, if you are a foreigner, you don't even need to have worked abroad. To have worked abroad. If you are a foreigner who have a permanent residence and you are working for the U.S. military as interpreter or translator, or you are working in other capacities but in executive or managerial role, then for as long as you are contributing to national security of the United States, they will waive the physical presence requirement for you. They will waive it for you. Now, let me recount. We've mentioned from part A, military related. Part B, US government or specified entity. Part C, certain media organizations. Now, before I go on, under this part C, I still have US firm that is engaged in the development of foreign trade and commerce, a public international organization of which the US is a member by treaty. I already explained that. Then part D, religious duties. And finally, part E, translators and interpreters or any security related position where they are in managerial or executive duties. So now let me quickly go back to start answering the questions. Okay, the first question today: what evidence or documentation is required to prove eligibility for an exception? Well, if you have listened to my explanation, I'm sure you will have seen I've listed what each category of exception we need to do, especially all of them, with the exception of the media. They need to file Form N-470 and then get it approved before going abroad, except the religious duties. For the religious duties, they can file the Form N-470 either before, during, or after. But for others, they must file the 470, get it approved before going abroad. The next question: are there specific forms or affidavits needed to apply for an exception? I believe I just answered that. Yes, Form N-470. The form, we explain the details of what type of documentary evidence that will be required. The next question, excuse me. How does applying for an exception affect the naturalization timeline? Well, it depends on the category. For all categories, is still within the normal processing time for citizenship. However, for the military category, that one is given expedited. In fact, special expedited, because I've seen naturalization application through the military that was commenced and completed within 2 weeks. So those ones are specially treated, because even the naturalization is done at the military base. They don't come to USCIS. It is the USCIS officials that will go to the military to go and perform it for them over there. So they don't even come to USCIS. So it's very, very expedited. But that is only for the military. For the others, you go through the normal route. But right now, naturalization is very fast. Within 3 to 4 months, you get it adjudicated. The next question: do exceptions to apply to contractors supporting U.S. missions? Yeah, for as long as you are working for U.S. missions, yes, it covers everybody. I mean, people working for U.S. missions are not in the military. So is either for as long as you are a permanent resident, yes, whether you are working for them full time or you are working for them as a contractor, it will not matter. If you look at the Iraqi wars, 80% of the people that were working in Iraq, they were contractors. All the military equipment, all these things, they were being handled by contractors. America is a capitalist country. America is not a Unitarian system. Many of the US military, they get their supplies, they get their support from contractors. Even Elon Musk, the richest man in the world, all the whatever the satellite thing that they are doing, all these things are based on contract. They are not US employees, but they are US contractors. Yes, contractors will be eligible. The next question: are there exceptions to humanitarian worker or employees of international organization? I don't understand this. I already said what the applicant will have to show. If the applicant are employees of international organization that the US is a member by treaty, yes, they will qualify. There's no need for humanitarian exception. For as long as they are working for that organization and they are a permanent resident and they want to become a US citizen, but they are not able to meet the physical presence because the organization they are working for posted them abroad, yes, they will qualify. And of course, they will need to file the form N470. The next question: what happens if the application for an exception is denied? Well, the denial letter will state the reason. So if the reason is what you believe you can overcome, you can apply, you can file N336 to request a review. And if you believe that the reason for denial is what you cannot overcome, just reset the button, reapply when you meet the requirement. That's all you need to do. But if you believe that the denial was in error, you have a right of appeal. The next question: are there exceptions to individuals working in certain countries or regions? No, the exceptions are universal. There is not country specific. For as long as you meet the requirement, you are already a permanent resident. The problem is just about physical presence, and you meet this requirement. It doesn't matter which country you are working. It doesn't matter. No country is exempt under this particular rule. The next question: what happens if someone spends significant time abroad caring for an ill family member? Can they request an exception, and how do they prove this? No. As you can see, all the 5 categories does not involve family members. You don't fall into any of them, except if your immediate family has been in active military during the time of hostility. you can use that. But other than that, there is no exception for ill family members. What ill family members can do if you have documentary evidence to prove that your extended stay abroad was as a result of ill family member, what that will do is just to preserve your green card so that at least they will not revoke your green card. Because as I stated when I was dealing with the requirement of green card, if you stay abroad for 1 year or more, there is a legal presumption that you abandon your green card. So this is where you have to you have to overcome the presumption by showing that, look, I did not intend to abandon my green card. I was only abroad because a family member was sick and I was unable to leave him or her behind. That is why I was abroad for an extended period. So that will only help you to safeguard your green card. It will not give you any opportunity to meet citizenship requirements. The next question. Oh, this is a note from you.
Yeah, I usually try and do it at the top, but
Okay.
yeah.
I think I see. Okay, the next question. If someone returns to the US after years of working abroad under an exception, how long must they wait before applying for citizenship? Oh, apparently this person didn't follow what we did today.
Well, it was before.
Eh?
It was sent before.
Oh, okay. So because the thing is, before you even go abroad, file for as long as you meet the condition, file Form N470, get it approved. Once you do that, even while you are abroad, you don't need to come back to apply for citizenship. You can apply for citizenship when you are already abroad and you will still become a citizen. You don't need to come back here before you can apply. The only one that requires you to return to the US after the end of your service is the one the media, because that one does not give you the opportunity to file 470 before leaving. So because you can go without filing the 470, that one is telling you that you must give you must provide you must have the intent to return to the US and live in the US after your media duties abroad is over. But for others, you don't even need to come back to apply. So you can apply for citizenship while you are abroad if you already have the 470 approved. So you don't need to come back. So there is no period of waiting or doing anything. No, you can apply. For as long as you meet your 5 years, just go ahead and apply. Because the physical presence that you are required to be here for 5 years, that will have been waived for you. So as soon as you meet the 5 years, just apply. It doesn't matter whether you are already back here or you are still abroad. If you are still abroad, you can apply from there. If you are back here, you can apply from here. The next question. What happens if someone was eligible for an exception but didn't file the required paperwork until after returning to the US? This is an open thing. I don't have a ready-made answer. What I will do, if I didn't know and I already came back, I will still go ahead and file the 470, attach all the necessary evidence, and wait and see what USCIS do. If they approve it, then I will go ahead and approve and apply for my citizenship. But if they don't approve it, they will tell you why they cannot approve it. And then, you follow. The next step will be determined by what their reasons are. Excuse me. The next question. How does an exception work for individuals pursuing academic research abroad but who maintain ties to the US institution? Well, this question is not very clear. Is it performing academic research on behalf of a U.S. organization? Yeah, if it is that, like I said, before you go, just apply for the N470. So once the N470 is approved, you go abroad and continue your research. As soon as you meet the number of years required, if you are within the 3 years category, 3 years after, apply for your citizenship. If you are within the 5 year category, 5 years after your green card, apply for the citizenship. For as long as you are filed and approved for the 470, your citizenship application will be approved. At least the physical presence part of the requirement will be waived for you. The next question. Are there any exceptions for green card holders stranded abroad due to visa processing delays or emergencies such as natural disaster? Oh, this person is talking. I don't understand. How can green card holders, if you already have green card, is this question talking about somebody still applying for green card or somebody who already have green card? Because if you already have green card, why will you be talking about visa processing? There's no visa processing for green card holders. If you have green card, you don't use a visa. What I can think of with this question, maybe this person is saying that, but again, why would you need a visa to apply for a visa if you are already a green card? The only thing I can think of with this question is that maybe this person has a green card that is about to expire, or maybe expired while abroad, and then needed to maybe to file something like SB1, and then maybe there was visa processing delay. I honestly don't see how this question is relevant to what we are discussing here. I don't understand. Well, if the person who sent this question is listening, you can send a clarification. I honestly don't understand this question, because what we are discussing today is about waiving the physical presence requirement for citizenship. So in other words, you must have been a permanent resident first before you start talking about citizenship. If you are not yet a permanent resident, we can't even be talking about citizenship, except if you are the children under 18 of a U.S. citizen. That one, yes, that will affect citizenship application. But for that one has nothing to do with physical presence, because if you are the child of a U.S. citizen and you are abroad and your parents are applying for green card for you, as soon as that application for green card is approved, it is citizenship that will be given to you. So they are not even going to give you green card. So you will not even need to apply for citizenship if it is that category. Because if you are a child of a U.S. citizen and they apply for green card for you abroad and you are under 18 at the time, they don't give you green card, they give you citizenship right away. So that will still not apply to this topic. So I'm trying to understand how best to answer this question, but I don't see how this question is relevant to what we are saying. Permanent residents of the United States do not need visa. So you are not going to have any reason whatsoever to apply for visa if you are a permanent resident. All you need, if you go abroad, all you need to come back is your passport and your green card. That's all you need to come back. So you don't need a visa. So visa processing delay does not affect this topic at all. But if there is any other thing that you have in mind that this question didn't reveal, even though it's already past our time, I will hold on for a few minutes. Please, if you can clarify it, I will explain it. But I'm sure if you also listen to this podcast from the beginning, you probably already got an answer to your question. But generally, visa processing delay does not affect green card holders. Except another thing I can think of, maybe this person, maybe if you are abroad and you lost your green card, because I'm just thinking of somebody, anything that can take somebody to the embassy.
Or the green card expired?
Yeah, maybe somebody is abroad, lost the green card, or the green card expired while you are abroad. Those are the only things that I can see that has to do with going to the embassy. Other than that, I don't see anything that will require a green card holder to have to visit the embassy. But even in the case of these two, whether your green card is lost or misplaced, or whether your green card expired while you are abroad, that has nothing to do with waiving the physical presence requirement. If you meet any of these conditions, if you are in the military, if you work for US government abroad, or certain classified employers, or if you are translating for the US military, or if you are working for a US media abroad, or you are working for US religious organization abroad, if any of those five categories, if you meet any of those five categories, yes, you will still be protected irrespective of whether you are stranded abroad or not. But if you don't fall into any of that categories, your staying abroad, your delay abroad does not waive your physical presence requirement, because it is the day that you enter the US that the system will record for you as your date of entry. And so if you have stayed abroad for more than 6 months at a stretch, that will definitely erase any physical presence days, weeks, months, or years that you have accrued. So if that is the question, yes, this exception will not affect you. This exception will not be applicable to you. Please let me know if there is any follow-up to that particular question. Okay, the next question, and probably the last for now, are there any specific situations where an applicant should avoid pursuing an exception even if eligible due to potential complications? Well, I don't see any except for lies. Yes. If you are going to lie, please don't. If you are going to fabricate documents, please don't. Yes, those may be problematic, because even when that problem is resolved, you will never be able to become a citizen. One of the major requirements of citizenship that is different from green card is good moral character. Good moral character is not a requirement for green card. You don't have to show that you are a person of good moral character for green card purpose. You only have to show that you do not have criminal record. You are not a convicted criminal. That is all you need to prove for green card purpose. But for citizenship, it goes beyond that. For citizenship, you have to prove that you are a person of good moral character. Even if you owe IRS taxes and you have not paid on time, even if you have a payment plan agreement with IRS, citizenship can still be denied on that ground that you are not a person of good moral character. For citizenship purpose, if you disobey certain laws, even something simple as traffic laws, even though you are not convicted, you are not sent to jail, maybe you are just given citation, they fine you $200 and you pay it, the citizenship can still be denied for that purpose. Citizenship can be denied if they believe that you are a drunkard, even if you are not convicted of it, even if you are not charged or convicted, it can still be denied. Let me give you an example. I remember a long time ago, when I attended my own citizenship swearing in, I remember the district director telling us that, oh, welcome as a fellow citizen. Right now, one of the things that makes this country different from any other country is the American dream. When we are talking about American dream, if you are driving on a highway and you see a car, you see a vehicle that is stranded by the roadside, it is your responsibility as a fellow American to stop and help this person that is stranded. Do you know that citizenship can be denied if you fail to do that? So this is what we are talking about. So good moral character is key. Without without despising Nigeria or anything negative about Nigeria, I'm a Nigerian as well as an American. But I can tell you, it is the opposite in Nigeria. If you see a car stranded on the roadside in Nigeria, if you stop, you may be attacked by hoodlums. You may be attacked by armed robbers. So if I'm driving in Nigeria, I see a vehicle stopped by the roadside, I will just pity them. If I'm in a position to help, maybe I can call the police or call Federal Road Safety to come and help them. But I'm not going to park to help. Because if I park and then I'm attacked, people will say, why would you do that? You should know better. But it is the opposite here. Here, as a good American, as a fellow American, you are supposed to stop and help. Even the police will stop without you calling them. People will park. They just see you stranded on the roadside. People will park and offer help. I remember, Marisa, if you remember recently, I came back to the office and I was disturbed. I told you about this man that I saw on the roadside the day I was rushing to court. It was a corner piece. By the time I saw the person, I said the person dressed in a black suit that I felt was a lawyer. So I didn't see him on time. By the time I saw him, I slowed down. I wanted to reverse, but multiple vehicles were behind me. So I was unable to help. That day, throughout that day, I felt the guilty conscience that, oh my God, I should have helped this man. I felt the guilty conscience throughout. And I remember when I came back to the office, I mentioned it. So something as simple as that can disqualify you from citizenship. So to go back to this question, is there anything? Let me be sure I got the question. Yeah, are there applicants who should avoid pursuing an exception even if eligible? The answer is yes. If you are going to fabricate documents, please don't do it. If the US organization that you are going to claim that you are working for, if this is not a legitimate employment, please don't do it. Because if you do it and they manage to cut you, it will do extensive damage and you may regret it. It may even lead to you losing this green card we are talking about, talk less of citizenship. So if this is not a legitimate employment, please don't do it. I believe that's going to be my last response on that topic. So did you get a follow-up?
A green card holder who applied for a re-entry permit to remain abroad for an extended period, but experiences delays in the issuance.
Oh, okay.
Can I read the question? I don't get it. Can you please pass it to me?
Well, these are examples of it.
Is it a follow-up to any of the questions that I've answered?
Yeah, the one about delays.
How come I'm not able to see the question on my phone?
No, it's on the phone.
Oh,
It's
okay.
not on YouTube.
Okay. Is it the re-entry permit delays?
Yeah,
Okay. This is a follow-up of the original question.
yeah, it's an example of what could
Okay. A green card holder applies for a re-entry permit to remain abroad for an extended period, but experiences delay in issuance. If the permit is not granted in time, they may not be allowed back to the US within the required time frame to maintain their continuous residence. Is that the question they want me to comment on?
Yeah. Well, that's an example of what could lead to it.
Okay, example of what could happen.
Yeah.
Well, let me say this. It is very unusual for re-entry permit not to be approved. The only thing that can make it to be denied, to my knowledge, Re-entry permit, I-131, you have to apply when you are physically present in the US. So if you are already abroad before you apply, that will be a ground for denial. Now, assuming that it is denied,
Not denied, delayed. Just
no, delay does not affect it. I read there delay and denied. Now, for delay will not affect it because anytime you come back, if they raise it that, oh, you've been gone for a long time, how come are you just coming? You tell them that yes, you knew you are going to be abroad for an extended period, and that is why you apply for travel permit before you departed, and you show them the receipt notice as evidence that you apply. So from the receipt notice, they will see the date that you apply, and they are able to pull the system and see your application anyway. So that will not prevent you from coming back. It will not affect anything. But does that have anything to do with the question of exception to the physical presence? I don't think so, because if you met the physical presence, you will still be eligible, and if you don't meet it, you will still not be eligible. So those are two separate things. This one only affects your green card, but it will not affect your green card if you have applied for the travel permit before you departed. So any delay, it doesn't matter, even if they don't issue it within 2 years, that's not your problem. You have played your part. You don't have control on when it is approved or when it is not. Your own responsibility is to apply. And for as long as you have applied and you have your receipt notice, if fingerprinting is required, you have already been fingerprinted, you have played your part, and that is it. You wanted to say something? Oh, okay. Well, I believe that is the last question, and we are done for today. Any other question? Well, on this citizenship exception to the requirement of citizenship, we want to say this is where we'll be stopping today. We also have another podcast on general citizenship questions, so you can see that. Please remember to join us next week again for a new edition of our podcast with a new topic. Until then, always remember to invite your family members, colleagues at work to join us every Wednesday, 12 p.m. Central Standard Time. Currently, that is 12 p.m. here in Dallas. That is currently 1 p.m. Eastern Time. That is currently 10 a.m. Mountain Time. And that is currently 7 p.m. Nigerian Time. God bless you, and we hope to see you next week. Thank you.